Going to be starting here in a minute. I am the owner of Section8Consulting.com, and I work with clients, thousands or more, 1,000 or more clients every year. And today we're going to be talking about disability and accommodations. So there are two principal things we're going to be discussing, and we're going to get highly technical, and we're definitely going to talk about some of the legalities of this. Now, before we get started, I'll let you guys know this is not going to be in relation to accommodations or modifications for those that are dealing with employers. This is for housing. It's more specifically those of you that are using Section 8 or low-income housing, okay? That being said, I'll put up some links up here. Now, one thing I want to tell you guys is I'm going to be doing accommodation forms. It's going to take me a couple of days. Because there's a lot that goes into this. You wouldn't believe the extraordinary amount of information you have to consume to just basically understand what these accommodations are, how they're essentially declining most people, and how to get around that. So we're going to talk about it, and this will possibly be 2 videos because there's simply no way to discuss all the legal topics. So first thing I tell you is pause the video after I give you this little bit of information here, because you're going to want to investigate these particular laws. Look, whenever you're wanting a modification or an accommodation, you don't just simply fill out a form and make a request. You have to back that with legal language. You know, that's what it comes down to. Is it fair and is it reasonable? If you don't have any law verbatim to back it up, then you're just making, a basic accommodate. You're just making a basic request, which they can decline. Most of these are going to be reviewed by their in-house counsel or their attorneys. So, all right. So, getting started, what we're going to review real quick is going to be Section 8504 of the Rehabilitation Act of 1973, best known as Section 504. We're also going to be discussing Titles 2 and Title 3 of the Americans with Disabilities Act of 1990, which is under ADA law. The Fair Housing Act of 1968 as amended and is now the Fair Housing Act. The Architectural Barrier Act of 1968, and also Title 24, C.F.R, Part 8, and so on. Now, what I'm going to do is we're going to go over some of the preliminary information I need to understand. Now, in most cases, when housing authorities are fairly large, let's say you're in a city of maybe 50,000 or better, you should have a legal compliance officer, in other words, attorney and house counsel, which is responsible for monitoring compliance with the policy and shall be available to applicants, residents, participants, staff for discussion issues, questions regarding, and also the interpretation, implementation of any type of policy they may have. Now, just so we're clear, after much investigation and research over these years, I've learned there is not a format in which either employers or people that deal with the housing authority and housing really don't have an operational manual. It's a construct of many different laws, and they can decline you based on many different reasons, and they can accept you for as many reasons as well. A lot of larger companies, as well as housing authorities, develop their own operational manual that kind of tells them the loosely fitted architecture of how they may want to review and investigate your case. Because remember, this is an investigation as to whether or not it would be reasonable. And you'll hear that word reasonable a lot because it's going to be what your case hinges on, besides what's written in federal code. So beyond that, we're going to get into definitions, and these are important definitions that you need to understand very well before you file for an accommodation or a modification. An individual with a disability is defined as a person who has a physical or mental impairment. And I think the key word here is substantially limits one or more life activities. And we will discuss what major life activities are. These are things that would create a barrier that would, affect your quality of life. As used in definition, the phrase the physical or mental term impairment includes any psychological, and again, key word, any psychological disorder or condition, cosmetic disfigurement, anatomical loss, meaning losing limbs, affecting one or more following body systems, neurological, suggesting throughout the body and brain, your skeletal system, sense organs, respiratory, including speech organs, cardiovascular, your heart, reproductive, digestive, urinary, your blood system, and lymphatic system. And some of these I can't even say. So I'm going to link up a manual where y'all can read these particular ones. Any mental or physical disorder, such as a mental retardation, which I think is probably a highly inappropriate term. I would say a person possibly on spectrum. Um, Organic brain syndrome, emotional or mental illness, a specific learning disability. Again, specific. The term physical or mental impairment includes, but is not limited to, such as diseases or conditions of orthopedic, meaning back, visual, speech, hearing impairments, cerebral palsy, autism, epilepsy, muscular dystrophy, which is better known as MD, muscular sclerosis, which is known as MS, cancer, heart disease, diabetes, mental deficiencies, emotional illness, drug addiction, and alcoholism. And let me just, I mean this is only as a pun. You drinking, being an alcoholic and falling down the stairs does not qualify you for an accommodation, okay? Because we do have some lunatics that would actually file asking for that kind of accommodation. The definition of a disability does not include any individual whose current use of alcohol prevents the individual from participating in public housing programs. In other words, Section 8 in its entirety, or activities or other housing authority programs, whereas participation by reason of such alcohol abuse would constitute a direct threat to the property or safety of others. Additionally, this definition of disability does not include any individual who's engaging in illegal drug activity related to criminal activity or any type of drugs, or who is unqualified to participate in the public housing or other programs and activities in accordance with applicable housing authority policies and HUD regulations, as mentioned earlier. Generally, individuals with a drug addiction that are engaged in and are able to evidence full participation in the appropriate treatment programs are qualified. In other words, if you're a drug addict on a rampage, no. If you're recovering, yes. Meeting major life activities means functions such as caring for oneself, performing manual tasks, walking, seeing. Let's go over that, slower. Performing manual tasks, walking, seeing, hearing, speaking, breathing, learning, and working. It covers a wide gambit of almost every sense that a human has. Hopefully, you guys can hear me okay. A reasonable accommodation is defined as a change, a modification, an alteration, adaptation, a policy, a procedure, a practice, a program, or facility that is necessary for the qualified individual with a disability to have the opportunity to participate and benefit from the program. That's pretty much covers the entirety of what it means to be a human and live, right? So I think again we come back to that word is what is reasonable and what is qualified, because we're asking for modifications and accommodations. So I'm going to stop briefly here to see if there are any comments. Looks like we got a few, so I'm going to take those. Again, this is going to be long, and it's not intended to entertain. I'm not a children's party clown at a party, and I'm not going to blow up balloons. We're here to discuss these things on a factual basis, and it may be intently boring from a middle-aged white guy, but oh well. We'll have to get through that, and we'll put something spicy in here in a minute, okay? I just want to get through the technicalities. JJ22, what accommodations, reasons can I use? I live in public housing, Yoka. I was just now about to fill out a form, and your notice popped up. That's a good thing, right? Well, JJ, the thing about it is I need to get a lot more information than just that. It's not as simple as this appears. I'm pulling from probably about 16,000 pages across maybe 8 different federal laws. And so I wish there was 3 steps to an accommodation. If you run across a video that says 3 steps or 3 tricks, or this is how it's going to go, they're just full of shit, okay? You'll find the information you need here, but we'll need a little time to get through it. So I appreciate you asking that. I'll be able to get some more direct answers. I would just say, have a cup of coffee, pause the video, start the video as we go, and learn what you need to learn. And if you don't, you can always contact me, JJ, and I can help you with your accommodation letter. Mona G. I have two sons that are twins who are now 20. Both have autism. I have a lot of clients that I deal with that are on spectrum, have autism, and so it's actually pretty common. I deal, over 40%, I'd say over 40% of all my clients do suffer from mental or physical disabilities that require accommodations and so on. So I'd say that a lot of what I've done over 20 years is working with folks that have a lot of difficulties. That's what makes it a little bit more interesting is being a consultant in the respects that I am, is a lot of consultants do not want to deal with anybody that has mental health issues and other things because they view it as complicated and over sophisticated. Apparently, I like pain, but I don't see it as painful. I quite enjoy helping my clients. I'm probably one of the last handful of people that take on people with mental disabilities, drug addiction, and so on. You have to roll with the punches. You either enjoy what you do or you're out for a paycheck. And I think most consultants have exited the consulting areas a long time ago. I have not, and I'll continue to do it till I take my last breath. Moving on, Violent RS. Hello and good morning to you. JJ22, can I use asthma and lead pain for an accommodation? Potentially. So we have to get a little farther into this, JJ. I know you're eager to find out. So we're going to reach that point in a minute. Just be patient, my friend. Tamika, I am a new subscriber. Welcome to the channel. Tamika, I hope you enjoy being here. We make videos on Tuesdays, Thursdays, and Sundays. There's a wide spectrum of personality. Sometimes videos can have a little profanity in them, and I tend to not sugarcoat shit. So if you're looking for the truth rather than tips and tricks, you'll likely get it here versus other channels. Lumen and Shadowboy. Interesting name of the day. How are you this morning? What about depression? Yes, depression in many variations does. But again, it's not the diagnosis that may help you get the modification or accommodation. It's what does it cause in your life? That's why when we get to this other part in a little bit, I'll have y'all write that stuff down so you can start formulating your letters, okay? Because nobody, here are your real options out here. You can hire an attorney for about $6,000 or more, okay, to help you with this and get it approved. You can work with somebody like me that's a few $100s, or you can spin the wheel and try the lottery. And most people fail because they don't understand how to structure. When you're making these letters, it's more than just speaking about disability. You have to structure and back it with law. You have to stay factual, and you have to state things they can't deny. And that's what most of you are not equipped with. I'm hoping that some of you will pull enough information to possibly help yourself. For others, you may need to, get somebody that does consulting work like me, or an attorney if you can afford to do that. It gets expensive because it's time consuming. I can tell you that, the topics that we're discussing right now, you won't find anywhere on Google. Not in the depth that it is. So, all right. So I'm going to jump out of the live comments. We're going to go back to accommodations. I have a lot of notes here I want to go over with you guys. So we stopped off at major life activities, meaning functions such as caring for oneself, performing manual tasks, walking, seeing, hearing, speaking, breathing, learning, and working. A reasonable combination is defined as a change, a modification, alteration, adaptation, a policy, a procedure, practice program, facility that's necessary for a qualified individual, a disability to have an opportunity to participate and benefit from the program or activity. Program or activity would be Section 8, or HUD or Housing Authority. So now let's talk about what most of you are looking for. Examples of a reasonable accommodation within the housing choice voucher program. And let's be clear, there's a housing authority. It has the option to give you a housing choice voucher, a voucher. It also has the option when the housing authority owns a building, say it owns 50 units, then that would be project-based housing. If a private landlord owns a building with 100 units, they would call that tenant-based housing, okay, not project-based. Project and tenant-based depends. So project would be housing authority owns it, and tenant-based would be when a private landlord owns it. So anyway, let's get on to the examples of combinations, because I think that's what a lot of you are trying to pull from. But just because we discuss these things does not mean you have a well-qualified case. Just to be clear, it's not a smoking gun, all right? So you really want to listen to the rest of what I have to say. Allowing a live-in aid for a resident or program participant with a disability to reside in an appropriately sized unit. There are additional state laws out there in certain states, like in California. You may ask for an additional room based on genders of children, the age of the children, the age of the people there, or even whether or not there's a sexuality difference. But in the state of California, in certain areas, they consider your living room a additional room and can tell you to hang a sheet. Okay, so there's a lot to be considered with that. So one thing you don't want to do is get in a hurry to fill out these letters and then you send it, you fire it off, and you bounce it off to their legal counsel and you get it wrong. Well, guess what? It's going to be a hell of a lot harder your next go around to get this accommodation or modification. You really do want to have your shit together when you do this. I am not joking, because the perception after the first time of denial is it's going to get a whole lot harder for you. And at that point, what you're doing is you're pushing yourself into an attorney's office. And I can tell you the attorney is going to want a lot of money from you guys, most of which you guys do not have. Number two, making documents available in larger type, computer disk, and braille, providing additional bedroom for disabled family members' medical equipment, providing qualified sign language interpreters for applicants, residents, program participants at appointments with the housing authority, and so on, permitting an outside agency or family member to assist an application, resident, or program participant with a disability in a meeting, screening criteria, or meeting essential lease obligations, permitting requests for extensions of the housing choice voucher if there is a difficulty in locating a housing unit with a suitable accessible features or that is otherwise appropriate for a family that has been a family member with a disability. Let's talk about some of the in-house modifications. Okay, you're in a wheelchair, then maybe you need all the sockets on the wall to be up 13 inches. If you can't get around well, you may need rails in the bathroom. You may need a modification to the sink in the bathroom to go up so your wheelchair will go under it. It's just a wild number of things. But on the reasonable side of this is, could the landlord or housing, if the housing authority owns the project-based housing and you're requesting an accommodation, would it cost $15,000 to do so? If it costs that, then what you end up with is not a denial of what your request. What you're ending up with is negotiation. Again, there is no operational manual out here. That says that there are definitive ways to address this. That's why we're piecing this together the same way any attorney would do it, okay? Section 6.0, examples of reasonable accommodation modifications within the public housing programs. Examples of reasonable accommodation modifications may include making an offer of a transfer a resident with a disability to a public housing unit with the required accessibility features. In other words, if you don't have it in the unit you're in, then they can transfer you to another building. That often, rule number one, has been applied to give people portability when they hate where they live. Making a housing unit part of a housing unit, public or common use areas accessible for individual disability, providing an additional bedroom for disabled family members with the equipment, permitting the family to have a service or assistance animal necessary to assist a household member with a disability, transferring a family that is participating in the housing program to a larger size housing unit in order to provide a separate bedroom for the resident or with disability, transferring a resident with a disability that is participating in the program on a ground floor. So you're on the third floor, then they can put you down the bottom floor. Sometimes accommodations aren't anything extra in cost, especially when you request modifications and accommodations that don't cost any money, that may just be a geographical change. Those are usually easier to get past. Allowing a live-in aid for a resident or program participant with a disability to reside in an appropriate size unit. So no matter what the voucher is written for, say your voucher says you may look for a place that's $1,200 and you have an allotment of 2 bedrooms. Well, if there's an accommodation top of that, then it could be expanded to 3 bedrooms. Another exploit that's something that some of my clients use in order to increase the size of the apartments they rent. So there's a dark side to this, accommodations to getting what you want when you actually don't have a qualified. I'm not going to discuss how we should probably do that, but providing accessible parking space for a disabled resident, providing qualified sign. And I think we talk about interpreters and all that for the standard ADA compliance. Now, because a reasonable modification involves structural changes made to an existing premise, The housing authority is only able to consider requests for reasonable modifications on properties that it owns and controls. So when you make a reasonable request, you cannot do this with a landlord. So if you want to submit a letter or a form, if the housing authority is giving you a voucher and you're living in a property owned by the housing authority, you may address the housing authority. If you're at a private landlord, you would have to submit that to them, and then they can either review it and decline it, or that we could probably just take that to the Justice Department or FHEO. Okay, so you would have to submit it. So there is a documented process. A lot of you filling out forms to start with, you should have started with notification, which means I have a problem. Could you help me? That's the first step. You don't go immediately to fill out an accommodation form. I would suggest you guys not verbalize these things, but actually put everything in writing. If you're going to put it in writing, make sure you're handing it in with a witness, a friend with you. If it's a mail, you need to be certified, signature, tracking number, so they've been served. And look, don't start with leaving messages and talking. There's no evidence that you're really doing that, so don't do it. Policy application. So applies to individuals with disabilities participating in the following programs. Applicants for public housing, better known as project-based housing. Applicants of the Housing Choice Voucher Program, which is the voucher that gives you choice to go rent from a private landlord. Residents of public housing developments, which is also known as project-based housing. Participants receiving federal financial assistance that are conducted or sponsored by the housing authority. So the housing authority clearly has other programs like FFS. So we talk about procedures real quick, and then I'm going to pause on procedures and go back to the comments section. Looks like you've been hammering away at these comments. So Lou Man and Shadow Boy, let's see. Jalen, thank you. Michelle Hyatt, you have such a lovely heart. Well, thank you. Some days I do, some days I don't. I was quite jaded and bitter with a client the other day. I regret that deeply, but I was very tired. You know, one of the interesting things about my job is I'm like most humans. You know, we have good and bad days, and sometimes I'm not always constructive with clients. I've shown an enormous capacity to be compassionate towards others. However, I do have clients occasionally that will frazzle you. You know, it's hard to deal with them because you're trying to help them. They're like people that are drowning that don't want to help themselves. And we've had a lot of cases like that lately where I've had to let clients go because they functionally don't want to do anything. They have a delusional concept of what life is, and they believe everything should be handed to them. And those are the most difficult cases to deal with. And, you know, I have homeless people that put more effort in. You know, that's crazy. So I guess I'm complaining a bit. So thanks for bringing that up and making me train my thought on that. Rosalind Mitchell, hello. This is Rosalind Mitchell. And again, I'm from Flint, Michigan. Let me ask you a question. Is that the Flint where the water went bad, all the lead and craziness? I'm just curious, Rosalind. Anyways, Rosalind goes on to say, and by the way, it's a live video, guys. I'm reading from chat comments. I'm in Flint, Michigan. I have a Section 8 voucher filling accommodations now. My disability, they told me that the aide has to live with me. In most cases, that is true. If your assistance from the aide is going to be greater than 12 hours, then they should be living with you in most cases. And then you probably would want to ask for the accommodation for a modification to your voucher to have a larger bedroom, or moving to a different property, whether it be the housing authority or so on, to get an additional room. Hi is a new interesting name here. Can you discuss requesting accommodation to rent from a landlord that is a relative if you have a disability? Well, cheaper rent is not an accommodation. That's a financial problem if that's what you're suggesting. All right, so we're going to move down and we're going to discuss some policy and procedure again. Look, guys, this is a lot of information, and it's constructed quite legally. The goal here is for you guys to pull little jewels out of this. It's not for you to hear it as a definitive answer. And believe me on this, whether it's an attorney or a consultant like me that's doing letters for you guys or helping you with your case like this, it requires a lot of research, okay? Most of the accommodations and modifications being requested these days and in the past, most of that was the laws were designed around people and employment and employers. So you find that on a factual basis, there's not a great deal of information out there in regards to housing authorities, their policies, procedures for modifications, and so on. And then it's still at the good judgment of what the law is. So you have to take an interpretation of the law. So you're writing out these letters and you're having to use things like I have been denied. I have been discriminated. So there's particular words you're wanting to fit into this, and then you're submatching under that the exact excerpt out of particular U.S. Code, Title 24, ADA laws, and so on. You need to be able to back this. And furthermore, you need to show a list of things. And I'm going to go over that list of things here in a minute. And I think that's another big chunk of it that you guys are looking for is the policy and procedure aspect of this. So, right now, let's just discuss procedures. A person with a disability may request a reasonable accommodation during the application process. I think we went over this particular part, so I'm going to move on. Individuals with a disability may submit reasonable accommodation requests to the housing authority manager or legal compliance officer in writing, orally, or by other equally effective means. I would not take that advice. I would suggest that you put it on paper and that either paper or email, and make sure you have receipt of them receiving that. Okay. We live in a nefarious world where sometimes the other side, the other party's not playing fairly, and you need a matter record of this stuff. The request for a reasonable accommodation request form is available usually at most housing authorities, but some housing authorities in America are just little houses with one little old lady working in there. I can assure you there's no attorney in the building, and she certainly does not have policy and procedure. And in that case, you definitely would want the letterhead of a consultant or an attorney to compel them to see your case in the proper manner. Um, so the request for a reasonable accommodation form, beside it being available there, you usually can go to the main administrative offices if they have so. The housing authority assures that all reasonable accommodation requests are reduced to writing. Now, see, they're even suggesting that in policy, even though they just told you you can do it orally, they're suggesting they're going to reduce it to writing. In other words, they need to transcribe that so we have a matter of record. Um, The housing authority will endeavor to enter in an interactive process with the requester in order to discuss the requester's disability related need for requested accommodation or modification and possible alternative accommodations. Look, guys, you may win the first round. You're going to get possibly accommodation, but it could be modified, and a lot of times it will be. In other words, you have proven you've offered the burden of proof. However, they are unable to meet the demand, so they may come up with an alternative, or they may go over several of them, where it's a negotiation to meet both the landlord's needs and as well as yours. Okay, so sometimes you're negotiating. Oh man, this is a lot to read, man. We're only on page 4, and I got to tell you, it's a lot. While it is always at the requester's choice to enter into interactive process with the housing authority, the process is intended to help all concerned parties in the process of seeking to provide an effective accommodation that does not pose an undue financial or administrative burden. That's the first thing most of you guys do. You sit there and you lock it up with either having extreme costs or you have extreme demands and you're going about the wrong way. And another thing is creating a laundry list of accommodations is the wrong idea. Look, you cannot go walk, you can go into Walmart with a shopping cart and get whatever you want. When you're dealing with accommodations, you need to focus on the most important one. Do not go in there, write out your life story in this form, and then expect them to make a ruling on 20 different accommodations you want. They're not going to do it. I always say when it comes to accommodation and modifications, it's better to chip away at it legally than it would be to sit there and overwhelm them because they're not going to tolerate it. All right. Reasonable accommodation requests are processed in the order they are received by the legal compliance officer. Any reasonable accommodation documentation, including a request form, is applicable. So, most housing authorities have a request form. You'll want to fill that out. And you usually can do it in person, you can do it by mail. You can do it by email. You can do it by fax, but I would not recommend calling and texting. Okay. If additional information or documentation is required, the legal compliance officer will notify the requester, being you, within writing, and the legal compliance officer does not receive the request for information within 21 days on the calendar, then the requested information will not be granted. Um, and also will be administratively closed, which means you cannot reopen it. Because this administrative closure is not a denial if the requester submits requested information after the 21 calendar days, the request for a reasonable accommodation will continue to be processed. Just notice you have a 21-day rule in that. But as a reasonable accommodation request to date that the requested information be received in the order it was received with all other requests. In other words, you have a waiting list just for this. All right? That's very plainly put out there. You have a waiting list for accommodations. Congratulations. Legal compliance officer will contact the health care provider named by the person with the disability requesting. Now I'm going to go back over that. Their attorney will contact your doctor. Okay, I'm breaking it down. And they will need to verify the accommodation. Now, look, a lot of you are under the impression, oh, I went to the doctor. They said I can get I have a disability. Thus, you equate that in your mind as I'm going to get an accommodation. Nope, that's just part of the project. It doesn't mean they can afford. Just because you have proven and the doctor has signed off does not mean that they can afford to do what you want. It doesn't mean that they'll be able to administratively handle the paperwork involved dealing with you, and they may decline you, they may move you, they may modify you. Modification means that they may also offer several alternatives, and if you reject or fail all of those, then they may do nothing for you legally. So the legal compliance officer will contact the healthcare provider in person and disability requesting accommodation to verify the information. If the healthcare provider's verification not received in 60 calendar days, the legal compliance officer will administratively close or request for the accommodation. So I think we kind of went over that one already. Within 10 business days of receipt of all required supporting documentation to render a decision, the legal compliance officer will issue a determination on the request for the reasonable accommodation and notify the requester, being you, in writing. Upon request, the written notification will be provided in an alternative format, like teletype. Oh, man. This is tough. You know what, guys? There are literally thousands on this, and I think we're going to move this to a general conversation because my throat's already starting to hurt. And to be frank with you, we could go on for days. And so I'm just going to talk to you on general terms. So now that we've covered some of the legal aspects of this, I'm going to link you up with that, and that's only fractional with this. So now you understand what's going on behind closed doors at your attorney's office. He's doing the same thing I'm doing. And that only covers policy procedures. We haven't even got into the 8 different titles on the U.S. Code and so on. It's a lot. All right, so I'm going to look at these comments real quick. So he said, I found your channel and you're talking about disputing electric bill and finding electric company. My current bill is $678. Honeybee GM Queen, how do you suggest porting to a new city? Well, you guys are all over the map today about that porting. So before I address porting, let's talk a little bit further about accommodation. Here are the facts that I wanted to bring up real quick, and this will be the last arduous part of this, all right? I suggest y'all pay close attention to this particular part because it's short and it tells you exactly what you need to be doing. It's a step-by-step process. So for you to leave the video now would be a bad idea. All right, so we're going to talk about individual disability requests that were with a reasonable accommodation. And this is, like I said, going to be a short one. The individual, sure, I've got it all down here. Okay, so here are the factors. The factors to be considered in determining whether an accommodation would impose an undue hardship or determining whether the cost of modification would result in fundamental alteration includes the following. The nature and net cost of the accommodation or modifications needed, taking into consideration that the availability of tax credits and deductions and / outside funding from the accommodation or modification. In other words, their budget. B, overall financial resources of the housing authority and the facility in which you reside. and then subsection 1, the number of persons aided, benefits, served, trained by, or employed by there. In other words, the number of people that would need this request. Section 2, the effect of accommodation modification would have, what would it have on the expenses and resources of the housing authority or the facility? When I say facility, I mean the place that you live. The overall financial resources of the local entity, including the overall size of the housing authority, the number of persons aided and benefited, the type and location of the facility, and the type of operation or operations of the local entity, then again, the housing authority. The impact of the housing accommodation or modification upon the operation or management of where you live, like an apartment complex. The ability to the impact on the ability of other participants to receive aid, benefits, service, training, and other facts. The impact on the housing authority to carry out its mission in order to serve you through that request. And then I think that kind of covers it there. All right, guys, we're going to talk about something else. I'm having a hell of a time with this. Let's see. So the portability question, let me address that real quick. So in portability, as you may know, there is billing and there's absorbing. For those of you that already have a voucher, you may choose to talk to the portability specialist at your housing authority if they have it. If not, it's going to be your caseworker there. You make a request to move your voucher from where you are to another county or to another state. Now, typically, the portability specialist there will do that once you let them know what housing authority. So if you're in New York and you're wanting to take that voucher, fly and move it all the way to, say, Miami, Florida, then the housing authority, the portability specialist in the Miami office of the housing authority would review your request and then determine whether or not they would absorb you or they would send a bill back to New York in order to keep you or deny you. Now, that's the simple framework of it. You still need to do your research on whether or not, if you received a voucher, let's say in Miami, and you move there, does the local market support having enough housing where you would even have an option to utilize your voucher? Where the city and county you're coming from and the voucher you have, clearly the voucher is worth a certain amount of money. Maybe they say to you, hey, this is your voucher. You may utilize it against $1,700 of rent. Well, the problem is different states, different housing authorities have different budgets. So what you may find with portability is you have a very worthless voucher and you're trying to move to a state and county where people are wealthy. And so that little old voucher you've got isn't worth much there. They may decline it or they may have to add to it. Accommodations and modifications. So you're sitting in New York, let's say, right now, and you've got a voucher you're using. You've been lucky enough to get a lot of modifications and accommodations. And so you decide you're going down to Florida and you're going to port it over there. Well, here's the problem. They can grab the voucher and just like they do with the cake, they can knock all the icing off of there, remove all the accommodations, modifications, strip it down to nothing, just a voucher that pays rent because maybe they can't afford to take on all the bullshit you have added to your voucher. And I'm not saying that it's just bullshit. I'm just saying that in respects to that doesn't mean that what you have with your voucher in that state's going to translate to the new county housing authority you may be dealing with in different states. So there are many, many things to consider. When you don't consider and plan this properly or have a fine understanding of it, what will happen is you'll end up getting there and you'll run out of time to use that voucher in a new place, and then you'll end up in a hotel and lose everything you own. Okay? I've had a lot of clients that called me and needed a bailout just from that. There's more than just contacting the housing authority and thinking they're going to process your portability. There's a lot of things you guys don't anticipate and end up in real serious jams with. Trust me on that deal. Tamika, I'm also in housing, so I'm going to answer a few comments here. I'm also in housing, would like to purchase my home. Do you have a video on how to purchase a home? I've got about 11 of them. The problem with videos about housing and home purchase is this. Not every so the housing authority gives you a voucher. That voucher pays the rent with a private landlord, okay, right? And so what happens there is you go out on your own merits and you purchase a home, and then that voucher that was paying that private landlord's mortgage They'll pull it back from the private landlord, and then they will pay your mortgage. You having a voucher does not equate to you going house shopping. It just simply means the voucher you have would no longer be paid to landlord, but would be used to pay against your mortgage, and you would still have your portion of the mortgage responsibility, just like you have your rent responsibility. Also, in most cases, when you utilize your voucher to help pay for that house that you went and financed, in around 10 to 15 years, they will stop paying anything. You have to take over completely. So a lot of you guys have the wrong idea about the home purchase program, and there's certainly a dime a dozen idiots on YouTube that are preaching all kinds of crazy shit that's not real about the home purchase program. You got to remember these slick talking little guys that get on YouTube. They don't know shit. They don't know their ass from a hole in the ground. They're making all these videos about stuff they just read off of Google. I mean, they might as well be sitting there reading the label of a toilet paper roll, and they're preaching on here about how they look cute and smart, but the reality is they don't know anything. I see that a lot on YouTube, you know. I've mentioned it many times about people being a party clown for children's birthday parties. The next day they think they're an attorney, and the next day they're in the mental ward, you know. So people can make videos about anything they want. Doesn't mean you should take their advice. So that is what it is. All right, guys. So, you know, the thing about, well, I wanted to just kind of wrap this up into one tight little thing. One, you need to give fair and reasonable notice to the housing authority and or your landlord. If the housing authority's got you in one of their properties, you need to stop by and write and say, look, I've got a disability. Um, I'm looking into getting an accommodation. Okay, that's called fair notice. Then, depending on how they respond, then you would want to have a accommodation letter or form. There's not always those are not always available on the website, or you drop by the housing authority and pick one up. It doesn't work that way. You're making your own. There are examples of that, and in there you describe. And if you're smart about this, you'll look at all the different laws. And if it says that this is a disability under C.F.R. 21837-27, and then you copy that, and then below that, this is my accommodation. Are you going to be denying me my accommodation, or will you be granting my accommodation? A lot of you guys fill out these forms. Well, you know, I just can't swing the mop the way I used to, and I might slip and fall off the first floor, and all this other nonsense, and then they've got you. So they take it, they shoot that to in-house counsel, they laugh, and they throw it in the trash and deny you. Just because you have a disability is not a guaranteed right to get a modification. Just because you want an extra bedroom doesn't mean it. You actually have to show supporting evidence. A lot of you are also in the belief that you can run down to the doctor there in Midtown, that it will accept a crispy $5 bill. You're on a sliding scale, and that any bullshit he writes on that form is going to get you an accommodation. Wrong. It just means that's supporting evidence. It doesn't mean they're going to grant it just because you have a doctor. If you don't structure these, if you don't know how to do it, call an attorney, call a consultant like me, because otherwise you guys are going to just fuck it up. Seriously, I deal with a lot of things over 20 years. This is one of these things that's especially hard to teach people. And then, you know, considering that this is going to be reviewed by an attorney, it's pretty serious. And taking a shot in the dark, you know, I really just don't advise it. Okay. You ain't got to hire me. You can hire any consultant, or you can hire any attorney you want, depending on how much money you got, because that's what attorneys want. They all do the same thing anyway. So now, if you've been lucky enough and you had a small reasonable request, you know, like you'd like your ashtray closer to your door, and they grant it, then congratulations. But a lot of this stuff can get rather sophisticated. Trying to envelop new medical equipment to cover every inch of the room to get an extra room. Look, there are things they look at, and they made their job and deny. Housing authorities are like insurance companies I've mentioned in many videos. You give them an opportunity and you do something sloppy in those forms, and they will deny. And look, they don't want to hear your mouth again for a year. Trust me on that. Once they deny you, you appeal it, you step it up to the Justice Department, you can step it up to fair housing, and then after that, nobody wants to hear from you anymore. You took your shot in the dark and you slipped off the mountain, and now you busted up, and nobody wants to give you anything. The game is up. You can sit there and have a cocktail, and they'll talk to you next year. I'm not joking about this stuff, guys. A lot of you guys, you run around the Google, the Twitter, and the Facebook, and you listen to all these nutcases give you advice, and You go and you pretty much throw a wrench in your own case. I see it a lot. I get a lot of people that hire me and think they're consultants. They get on the phone. Oh, I know the law. No, you don't. You don't know shit, man. You don't know anything. You read some stuff on page 2 of Google, and you just don't know anything really. So anyway, anyways, I'm trying not to beat you guys up too much. It is possible. At the very least, you should seek a professional advice. Okay, before, and I'm going to give you a few more recommendations. Before you actually get under your car and it falls on you because you decide to be a mechanic, maybe you should call the mechanic. Before you play in the breaker box with a big screwdriver and get electrocuted to death, maybe you should call an electrician. Sometimes, guys, you need to seek some professional advice. Not everything about the housing authority is designed to be DIY. I'm just warning you about that, because once you damage your case, don't expect anybody to fix that. There's no unwinding this. There's only trying to figure out new ways to try to address that. One lady screwed her case up so badly, we had to port her to another county with another housing authority that she hadn't dealt with before and do it the right way this time. Sometimes it's just hard to unwind what some of you guys are doing. You're sitting there with the mouse and you copy and paste and all kinds of nonsense, and you're filling out these forms and all kinds of crazy shit. I wish there was a better structured way to do this, but unfortunately, I don't have 80 hours to structure it and give it to you guys. A lot of the cases really do hang or contingent on what you're saying and whether you're backing that and whether your case is factual and would it actually improve the quality of your life. Can you demonstrate that? Have you taken photos of what would happen if they removed the wall and then you could actually pass your wheelchair that way? So building a strong case with this will give you absolute accommodations. Um, Having some delusional concept of thinking this is straightforward is not. It is designed to be convoluted. It's designed to make most of you fail. And if you do get a good worker at the housing authority, they're not approving your accommodation because of the law. They're approving it because they like you. And so there's lots of ways outside of the law to manipulate a system. Well, you know what? You're dealing with a rigged system, and then you're trying to manipulate. That's what most of you know how to do is just sweet talk. Well, look, that doesn't always work. Being chumps with the people at the housing authority doesn't always work. And then your game is up, right? So if you don't have a good worker there that's just willing to approve it regardless of the law, then yeah, that's what it is. So look, guys, I'm going to give you a couple links here real quick. And I'm going to have y'all read through this. Let's see if I can give it to you real quick. I'm going to give you a sample form from the city of Houston. I believe that you could base some of your argument on this if you want to, okay? This is a reasonable accommodation for the city of Houston. It actually gives you, and I just linked it up in live chat, it does give you a kind of the context of what you'd have to do, okay? It's a good read. There's probably another 70 documents, but unfortunately, I can't put all that into live chat, okay? All right. I'm going to take a look at the comments here real quick. Kelly Bellows says, just moved from Georgia to Virginia, my son and daughter-in-law. Any advice on getting Section 8 home there? Well, first, I would say you would want to give the housing authority a call to establish whether or not they actually allow that program, unless you're going to independently address Fannie Mae, Fannie Mac, and then pull out a conventional mortgage, first-time home buyer, or a USDA loan, which means rural. So you'd want to establish whether that program is available there. Otherwise, it's just a typical home purchase and will not involve the use of a voucher. Kate Cole says, salute you. Kate Cole says, I need help. Mr. Cole, you and everybody else. You know what, guys? I like to get killed. So we're going to talk generally now. Last Monday, 71 calls. So many people tried to call. The phone quit working and knocked me off for several hours. So I'll let you guys know on Mondays, it'll be a 24-hour wait to talk because it gets so difficult with that. And I got to be telling you, yesterday, I didn't return a lot of calls because I was sick, I don't think a lot of you guys realize I get up 4 in the morning and I often work till 11 o'clock at night on y'all guys' cases. I work on it when I'm in the bathroom. I work on it when I'm on the back patio. I work on it when I'm in traffic. I work on it when I'm grocery shopping. It's what I do. But it creates a bit of mental exhaustion at times because everybody loves wants the right amount of attention. We live in the time and age of Amazon, where everything is supposed to be delivered tomorrow or in 4 hours. Unfortunately, when you're dealing with all the complicated issues in relation to housing choice vouchers, housing authorities, public housing, low income housing, all that, there's no clear path. There is certain ways to manage it, and it does take time. All of it's about time and having patience, you know. And that brings up a new issue I'm going to close the video out with soon, not just yet. I had a client told me that I needed to burn in hell because, you know, guys, I work with a lot of clients and I always tell you your absolute participation is required. For the most part, I have great reviews over the years, and that's because I produce results in most cases. Unlike other people that sell unicorns and fantasies, I have a failure rate. It's 7 to 10% of the time. Again, you'd be better getting drunk at a casino and blowing your money than hiring me to do work for you in some cases. I try to turn down cases where I believe that would be no result, okay? I'm not a greedy person. I only take 4 consults a day, 4 days a week, and that's it, okay? I don't operate this 24 hours as a money mill. I do consulting work for people who actually need help, and I do it on a limited basis. That is it. So moving on to this client, you know, she told me I needed to burn in hell. I gave her a very specific set of instructions, and we talk about a person in water that is drowning. They don't want to help themselves. They want to continually send me, do you have any updates? Well, honey buns, if you're not going to do shit to help yourself, if you're not going to participate, and you think the tooth fairy is going to bring you a fucking voucher, okay, in the middle of the night, then you're out your tree. And I finally, you know, I was going to say, I finally had enough of her, and I killed the case. Look, most of the people I work with get it, but one thing I think that most people understand about me is you have two options in this world. You can wander around and have people lie to your face and make you feel good, or they can do the job for you and do it well. But in return, I would expect people to act and demonstrate and conduct yourself in an adult manner. And writing childish emails and acting like you're unable to even help yourself get off the couch is not my problem. I don't house train people, you know? And that's the reality. Otherwise, I would get along famously. Most of my clients, you look at even my live chats and most videos, most of my clients have been around for a long time, many of which are former clients, so we're just friends. You know, I've got ladies in Chicago I talk to all the time. A lot of my clients become my friends, at least virtually over the phone. Some have even done work for me. So, you know, I'm pretty personable until I find out that a client's a bad client. And then we have to let that neurosis go because those type of people will use anybody if they can. They create havoc and problems, and I always get a few of them every month. But this particular case really got me pissed off last night. And again, you know, one thing you learn about my business is besides the cordiality and talking about the legal aspects of cases, I incorporate very much my personal life and other views on life. It doesn't mean I'm right or wrong, and maybe I should burn in hell, but you know, and for us to keep it spicy, we got to talk a little personal. So I do include that in my videos. If you don't like it, that's fine. You know, you can always go down to church and see if Jesus will get you a voucher. And of course, I love God and whoever our creator is. But you know, the thing is, guys, you got to hear the truth before you understand how to handle your case. So, all right, looking at these comments here, equal love. Looks like the comment was retracted. K. Cole, much love and respect to you. One Queen says, are you available to take on a portability case? All the time. I love portability cases. As a matter of fact, it's one of the easier things I can do for y'all, and it doesn't cost that much to do. In fact, we blaze right through portability cases. Some do get kind of complicated, but I would say that of all the things that I offer, it's probably one of the least expensive things because there's a high success rate. I'd say our success rate is like 99.9. Only a few failures here and there. Equal Love says, does independent rehabilitation qualify for reasonable accommodation? I think so. You know what? If we're able to frame, you know, if you're able to frame your case up where I am in a right way to make them see it and then pelt them with 6 or 7 federal laws, then they would have little reason to deny. The thing about accommodations and modifications is, guys, you simply there's no list of approved and a list of denied. They deny and approve based on how well you present your case, and that's where all of you fail. You don't know what to present, how to present it, the right kind of evidence, and a lot of you are under the belief that the doctors know would be sufficient. It's not, and you don't know how to press the line. A lot of you pressing that line too far Many of you want to try to do 10 and 20 accommodations at a time. You should be chipping away, win one, and then you sneak in for another. The approach is very much wrong for a lot of you, and you're not backing it with anything. And so when you copy and paste or verbatim federal law into your request, what you're slowly doing is saying, hey, I'm not taking shit. I'm very serious. Are you going to confirm or deny what American Disability Act says? Are you going to violate my 2008 Disability Act? Are you going to violate Title C.F.R, Title 24? And you're putting very broadly. And so I think, okay, well, they're apprised of their rights. Putting in there, well, I just don't like the people at the housing authority. The air never smells very nice outside my apartment. I wish people would treat me better. Oh, by the way, can I get an extra bedroom? A lot of you are just writing nonsense. And I don't mean that to be ruthless or inconsiderate, but it's true. You're trying to address things the way you would deal with ordinary life situations. Look, accommodation and modifications cannot be addressed in the typical manner that you might imagine. And so you're trying to use your life experience to fight these accommodations and get these accommodations and modifications, but the reality, the method you're using will not work. Honeybee, when folks are rude to you, you do what's necessary on their part, then it's understandable. Yeah. Well, part of my job is accepting the unreasonable. Look, I've got clients. Let's talk about unreasonable and request. I have clients, I take on and they present later as they're problematic people. You can already see they're on the dark side more than they're on the light side. And you only realize it when you get involved with them, that they're contentious people to deal with. I only get a handful here and there, and I get rid of them fairly quickly. I'll shut them down fast as I can because this is what they do. They roam around and they just try to exploit anybody they deal with. And then, trust me, I've had people hire me to just harass me almost. But one thing they learn about me, man, is let me tell you, before the phone goes down, there'll be a few profanities, and then you'll figure it out. Like one lady, I'll go somewhere else. Well, honey, you just talked to the best in the nation that does this. So your other options are 211, calling the housing authority, and then call Make-A-Wish because there's nobody better at this than me. So you already burnt the best bridge in the nation. So where are you going to go now? The ditch? But you can't tell somebody that when their screws loose in the head. And I try to tell people that I'm going to call it the way I see it. If you've got a loose screw, honey, look, go check yourself in somewhere. Pill calls at 7:30 p.m. And when you get your noodle fixed, come on back and then we'll see if we can help you again. That's the thing. We have to manage expectations. And, it ain't Burger King. It's not going to be your damn way all the time. Matter of fact, consulting work is about collusion to work together, cooperation, and participation. It's not about you paid me and I'm going to be in servitude to you. I don't think so. That's not what consulting work's about. It's about helping inform you, educate you, weaponize your application, weaponize these requests and demands that you have so you have a fighting chance to deal with housing authorities, that you have a fine understanding of federal law, and that you're able to achieve what you need. And you're not going to get that from a slick talking, bubblegum, airheaded fool, rolling around YouTube thinking they're a master fidget spinners. You know what I'm saying? So that's part of that southern part of me where I just tell people simply the way I see things. Tamika, I saw a couple of videos that say you were in Arkansas. Welcome. Oh boy, that Arkansas. Y'all may have noticed I made a few videos about Arkansas, and I deleted a lot of them. It was a very unplanned trip. I bought some land and property out there on a wild hair, I guess. Sometimes men like women have midlife crisis, and we do some emotional things. I bought a house and some land and thought I could go live in the woods with all my cats and do consulting work. Well, I didn't know who I was going to be living with out there. I didn't understand the circumstances, and it unfortunately didn't work out. There was not much planning in that. But again, I have the finances to afford what I want, so I don't necessarily have to research things in order to go do them. Sometimes I can, lose 10 grand. It doesn't matter. So it's not, but I usually am pretty planned. So it was a miserable trip for a month. And I put the land back on the market for Arkansas. That's just not for me. It's too rural because there's cities, there's suburbs, there's in the country, living on the farm, then there's living in the woods, and then there's rural, then there's extreme. I was somewhere between rural and extreme, and it doesn't work for me. So, Rosalind Mitchell, this is Rosalind Mitchell again. I'm in Flint, Michigan. I meant to say that the state of Michigan Supreme Court awarded Flint 680 million. The governor at the time, Robert Snyder, now is pleading the fifth. Yeah, well, you know what? If Mr. Smith ends up on the sidewalk in Flint, Michigan, he'll probably get a brick in his head after the shit he pulled over there. That's reprehensible to poison a bunch of families and kids. I think all of you know me as a consultant, how much I care about clients, how much I care about the cats that I rescue. I've got so many of them. And when I see stuff like that, just like, why don't we throw the war into this, Russia and Ukraine? We think about that. They're just killing people arbitrarily, destroying the whole country simply because they can. Um, Man, there's so many remedies of that can happen in a flash to deal with Russia. I don't even see why the Americans are even scared of Russia. Russia ain't got shit. They got a few old bombs over there, a few little old nukes sitting there with dust on it. Who the hell's worried about them? It would take a matter of minutes to invade that country. I honestly, for what they're doing to those people, it's disgusting. So that's another one of those personal views I throw in the video. And some of you agree, some of you won't. So, that's how life goes on YouTube. You got to take the good with the bad. All right, guys, I think I've rambled on long enough. We talked about so many issues, houses, Arkansas, and this and that, modifications, and so on. So I'm going to leave you with this, couple more links. So this is our website. I am registered, state of Texas. I am a Texas. So I have a limited liability corporation. So, there's legitimacy in what I do. We have reviews all over Google, reviews, service reviews, and so on. You can look at them. So if you are struggling with a particular issue, let me say this. I practice consulting work in all 50 states, including Hawaii and Puerto Rico. I help nearly 1,000 people a year. In most cases go well. I'm well known, pretty much. I don't think there's any consultants in the nation that are actually greater than my reputation after all these years. I've outlasted most of them, so I'm pretty widely known. I've dealt with housing authorities. I've done witness work at the federal level, going to court, so on. And if you look at our community page, you'll see a lot of different people posting their vouchers. I don't buy or sell them, and I respect the law. Just like a good attorney, okay, and I'm not an attorney, if somebody committed murder and they hired an attorney, you'd want to get off. And how does an attorney do that? Well, it may not always be completely moral, but we understand what the loopholes are. If you understand how to exploit the laws, you shouldn't have left the back door open if you didn't want us to come through it. So a lot of what I do is being clever. Clever means I understand and found and able to penetrate that corporate shield and to get through and get things done. Okay, that's what it comes to. This is not about me sitting in a college for 8 years studying to figure out what everybody else knows. I know that and then that, even more. And I learned a long time ago when you deal with a rigged system, dealing with vouchers, housing authorities, accommodations, modifications, portability, and all that, you learn over time that playing fair isn't the only way to play. And if you're going to play the game, you better play it better than the people that designed it, or you will fail. Okay? So let me be very, very clear. I play to win in all my cases. I hope to win them all, and when I fail, I fail. That's part of life. If we ever live in a world where everything works out, then I would love to join that world. But for now, we live on Earth, and so I do the very best of what I can do. I encourage you guys to look around other places. There are other consultants out there that do a lot of things. But I think you always will arrive at one thing. You'll either arrive at my website or you'll arrive at my YouTube channel, because there's simply nobody that puts out as much as I do that is better known. And I'll let my own reputation speak for itself. So I don't really need to sit here and jack up my own reputation. So, all right, guys, I've enjoyed talking with y'all. And as a last note, I want to tell y'all about the kitten we rescued and had in the ICU. I guess the animal version of ICU. She's doing well now. So pretty girls, the Siamese mix, had bad owners, kept her trapped in a cage, messed her up pretty bad. We had her on IV and catheters for about 10 days. It was a very expensive venture, about $3,000. But it's not money. It's what the fact is. We were able to rescue her life through 5 different infections and so on. She's doing well. She's socializing, and she's living her best life. The main thing, she'll never have to experience the torment she did from her prior owners. And to be frank with you, the people who did this I hope when they take their last breath that it's the most miserable fucking experience they ever have. And I hope whatever's waiting on them, that they're able to, I hope it happens to them, you know? I can't stand people that take advantage or abuse animals, children, seniors, and women. That's just a part of my moral character. So, all right, guys, I've enjoyed talking with y'all. We'll see you Sunday. And next time, I believe what we're going to talk about is FFS program or self sufficiency program. I think I said the acronym wrong. We've never discussed that before, and I'd like to introduce some of you to that. If you're not on a fixed income and you don't have a permanent disability factor, then this is a good program, self sufficiency, and it also gives you the ability to get involved in possibly on your own home. It can subsidize part of your income. It does a lot of neat things. And this is for people that need the help for a little while, a couple of years, a little longer, and then will eventually like to exit the system. My goal for all of you is hopefully one day you'll use your income or fixed income to exit yourself from the voucher and to enter into your own home. Because the reality is, most of what you're paying in rent, you could really just be paying against your own mortgage. But since I don't have a broker, as I didn't go to school, go to college as a broker, I have to be careful how I tread on giving advice on real estate. Okay. So I have to give it to you from my own perspective and not in a professional manner. But I'd say my advice is pretty decent, and I've worked with a number of clients already. All right, so Rosalind Mitchell, if someone puts their voucher and they can't afford to stay in a hotel, they may need to find a decent homeless shelter in case where, well, when you do portability and you're on the fringe with that, you might want to check out boarding houses because rather than $100 a day at a hotel, you could have kind of like a boarding house where you pay $100 a week, and it's just a couple bunk beds in one room, and then usually the people that are at the boarding house aren't too crazy, not like it gets in shelters. And so there are some solutions to help you stretch money. The quickest way to bankrupt yourself if you're going to hotel while you're waiting on portability is dealing with a hotel. Okay. There's a lot better ways to handle this that give you the same kind of freedom. Going into shelters will restrict you by hours and time. And then, of course, if it's up to the shelter and their caseworkers, the little girls that work at the housing authority that just got their degree out the bubblegum machine, I can assure you your case will be no more important than the other 900 people there. And as long as shelters are funded by the United States government, then I can assure you one thing. As soon as they're unable, after about 30 days of the federal funds, when they're no longer able to profit off your back and you being on that rubber mat in the gymnasium, then I can assure you they'll be asking you to leave. And in most cities, they'll even restrict the number of days you can stay. Those numbers actually correlate directly with how much money they get. So if the government says they're going to cut them a nice, tasty little check, but they'll only give it for the first 10 days of the month, I can assure you their policies will be wrapped around that, and that your entire stay at that shelter will be based on how long they get paid to have you there on the gymnasium to feed you week-old pizza garbage, basically. I tell you a lot about shelters because I looked at some of their director reports, and I can tell you they're very much for profit. And even the ones that are religious, Jesus is never in that building with the shelters. In fact, the religious homeless shelters, in my opinion, are actually worse than any of them because of the bad actors there. It's kind of like the nuts running the nut farm. All right, guys, we're going to wrap it up here, and we'll see y'all again Sunday. All right? Bye.